Porter Williams.
Thank you, Mr Speaker. Far be it from me to stand between the hard-working members of this House and their Easter recess, so with your indulgence, Mr Speaker, I will keep my call on this bill relatively brief and around 4 key themes. The major implication, as far as I can see, of this bill is around ensuring child protection remains paramount to this House and in writing legislations, and I think that this bill does address some key points. There are some things, Mr Speaker, that many on this side of the House had some reservations about during the passage of the bill, and one of them was really around the sentencing presumptions and the issue around sentencing to curb reoffending. So there are provisions within the bill to deal with penalties for the manufacture and the distribution of the material, the objectionable material, that now potentially are inconsistent with the penalties with which an offender will be charged, will be liable to undertake for the actual abuse itself. I understand, or I hope that at some point our legislation will start to deal seriously with the issue of child abuse in terms of the penalties that are imposed upon offenders of that. And I believe that some of the work that the committee looked at goes some way to addressing that in terms of the repeated child exploitation, and that the committee agreed that that providing judges with a sentencing regime to reflect the seriousness of the reoffending would send a strong message to people, to potential offenders around the exploitation and abuse of children. There was also a concern expressed about sentencing presumptions within legislation within this bill and within others, and I think it was right to raise that as a concern, although in this case the members of the committee were satisfied that the seriousness of the offending should warrant that. Secondly, Mr Speaker, there was some discussion around the definitions of objectionable and indecent, and there was a bit of discussion around those terms being in recent times the term objectionable can mean something quite different from previous years. We live in a modern world where many things transpire. We are open much more to images and publications, much more than we were in previous times. So what we might tolerate, what might be objectionable and not objectionable, is a difficult thing to define. So we do trust in our judiciary to actually hold some standards for that and to make calls based on the specifics of the cases before them. Thirdly, I want to talk about the submitters. There was a concern around images that might be held on an electronic site that weren't necessarily provided by a particular internet provider. The provider is just a portal with which people can view the images, and they were concerned that they may be liable and may have some penalties imposed upon them, but this was well traversed during the passage of the bill and assurances given that that would not be the case. Finally, Mr Speaker, there was clause 13 I want to refer to, which does provide a new offence under the Crimes Act, but it did raise some issues in the committee and with submitters about the potential for entrapment. But the committee, after some deliberation, was satisfied that the law enforcement agencies are fully aware and experienced with the issues of entrapment, and that the judges have the discretion to exclude evidence that they believe is improperly or unfairly obtained. So I feel satisfied, and we feel satisfied in this side of the House, that those issues have been traversed. We do support the bill, and on that note I would like to wish members of this House a very enjoyable Easter recess. There are some significant things that are happening over this time, including Anzac Day, which is a significant day, 100 years since Gallipoli. So on that note, I wish you all a very happy Easter and a reflective time over Anzac. Thank you, Mr. Speaker.
Thank you.